Okay. Good morning. This is August 11th, 2020, and the board is convened to consider our docket today, which has, for the most part, evaporated with continuances, except for the case set for 10 o'clock on our hearing on our docket, which is a Goldman case, and that is a case number GLD 20-0001. And it deals with the Irvine Wood Recovery Facility premises located in Loveland, Ohio, and the fire department's citation number is noted on our docket. Um, let's have an introduction of Chief Kelly and Mr. Jetter, and then I will read a preamble that arises out of a case that was involved. It's called the Goldman case, and I'll read that into the records. But Chief, would you enter your appearance, and Mr. Jetter?
Good morning, thank you. My name is Steve Kelly. I'm the fire chief for Miami Township Fire and EMS.
And my name is Dave Jetter, the deputy chief of Miami Township Fire and EMS.
Thank you, Chief and Deputy Chief. All right, before we proceed, and for the benefit of those who are in attendance today, the case presently before us is what is called a Goldman case. A Goldman case is an evidentiary review in the citation process being used by the appellee to attempt to remedy an alleged violation of the code sections that have been cited. The responsible persons in this case had an opportunity under the Ohio law and the Ohio Administrative Code to timely file an appeal before this board. As a result of not filing an appeal, the responsible persons have waived their due process rights in this proceeding. By the way, that is a Court of Appeals case, and that holding is held for I don't know how many years now. This is a public meeting, so any person or persons representing the party listed as the responsible persons, as well as any citizen, is welcome to listen from the audience to the testimony. And I think Mr. Irvine may be present. The Board of Building Appeals is not legally required, nor will it permit the responsible persons the opportunity to make an opening statement, to present evidence, to cross-examine witnesses, or challenge their evidence, or to make a closing statement. And again, that's based on solid Ohio appellate authority. So with that, Deputy Chief or Chief, you have the floor, and you can walk us through the citation.
Thank you very much. We had a recent event that had been a series.
Oh, you know what? I do have to swear you in. I'm sorry. And Susie, you'll have to unmute. Would each of you stand, raise your right hand, and our court stenographer will administer an oath.
Okay. Do each of you swear or affirm that the testimony you will give today will be the whole truth and nothing but the truth? Thank you.
Thank you. Okay. Now you have the floor.
All right, thank you. We've had some history with the Irvine Wood Recovery Facility and located in Miami Township, of course, addressed with the city of Loveland. As recent as January 2nd, where the events that we go to for incident response mainly deal with oversized mulch piles, of which catch on fire usually at a time where employees are not on site and passersby see it because of the flame. We have inspected that place, annually as required by the Ohio Fire Code, and have continually had issues with the pile sizes, with the ability for the fire apparatus to access the piles and so forth. And as recent as January 2nd of this year was our most recent incident where we had a fire at that location. As of January the 7th, Chief Kelly issued a formal letter to Irvine Wood Recovery discussing what's been going on there since 2015, and then brought in the Ohio Fire Marshal's office, which happened on January 13th. And at the recommendation after that meeting of the State Fire Marshal's office, we did issue the citation and order that was sent to via certified mail on February 14th, of which you mentioned there was no appeal, and we're here to ask for our citation to be upheld by the Board of Appeals.
Okay. Questions of members of the board of either the chief or the deputy chief, and it may be that they want some more specifics with respect to the citation, but I'll open it up to my colleagues on the board.
Mr. Chair, I don't have any specific questions. I mean, I reviewed our the case documents that were sent in with our board packet. If the chief or deputy chief would like to have any of those pictures or any of the citations or anything posted up as part of the live event, we can accommodate that.
Okay.
And there's specific requests other than to answer any questions.
All right, well, that's fine. What relief, or other than to have the citation upheld, is there a monetary sanction that you're seeking?
Money, we did provide a $100.
You just broke up on us. Hard to hear you.
Directly seeking monetary a return of funds. We were simply asking for what we wrote to be upheld. Now, we did cite 4 different fire code violations at $100 per violation per day. Based on the recommendation that was given to us, that was like a minimum amount that we could apply, and that going forward, we would have to actually provide, because of a continuance with non-compliance to the code, we would have some ability to apply the fee schedule 15.
Yeah, you broke up a little bit on us with us, but I think we caught the gist of that.
I have a question, Carl. Are all 4 of the violations, have any of them been remedied?
As
now,
is in compliance.
could you
All right, you
repeat that?
broke up again, the audio's, yeah, if you could speak closer to the mic.
The fire codes are in compliance. He's fully in compliance as of right now.
Thank you.
Okay. All right, members of the board, what are your thoughts and sentiments with respect to upholding the citation in whole or in part, and assessing, if any, some monetary sanction?
I guess I'll start the discussion. I mean, I definitely would uphold the citation. There's a history of unsafe storage of this material. Obviously, to the extent that there's been multiple fire alarms or multiple fires at this facility over the past 5 years. I realize he's in compliance now. I guess I would suggest assessing a monetary penalty that the township and or their legal counsel could seek to enforce should there be an issue in the future. I would hold it in abeyance, considering that the violations have been abated at this point, but there's an ongoing history here, so I think there needs to be some teeth behind our citation if it should reappear.
How would we hold it in abeyance? What would it? I mean, in the end of the day, it's up to the fire department to choose to collect or not collect. But
I guess I would craft it or word it as a one-time civil penalty of X amount of dollars to be held in abeyance so long as the facility remains in compliance with the fire code.
okay. Paul, Neil, Brad, thoughts on that?
Would you state that with the fire code or just the 4 violations cited?
Maybe just the 4 violations cited, because I mean, I don't want to see somebody get tagged with $1,000 just because a fire extinguisher's not been inspected. I agree with you there.
I'm fine with Chip's recommendations.
Paul, Brad?
You're muted, Brad.
You can only assess them $1,000 per violation then, is that correct?
You could do $1,000 per day, Brad, so we could probably do however many days.
Since February.
Since
6
February. Yeah, I mean, you could do $150,000 if you wanted to.
I guess I was thinking something along the lines of a $4,000 one-time penalty, $1,000 for each violation, held in abeyance so long as that there's no future violations of those same issues or along those same lines.
That sounds reasonable to me.
I concur.
I'm good with it.
Do you want me to write it up, Paul, or?
Yeah, if you wouldn't mind, Chip.
Okay, Susie, we're gonna go off the record for a minute.
Okay.
Not sure what that is.
Let me
Back
share
on the,
this.
back on the record, Susan. Susan, did she drop off?
Okay. I'm on the record.
Okay, thank you. Okay, Chip.
The board hereby upholds the citation issued on February 14th, 2020, and issues a one-time civil penalty in the amount of $4,000 to be held in abeyance so long as there are no future violations of the same nature.
Chief Kelly and/or Deputy Chief Jetter, any comments with respect to that proposed financial sanction?
No, I think we're in agreement with that. And again, to Deputy Chief Jetter's point, our goal is not to seek monetary punishment, but just to keep the facility within compliance.
Thank you. Members of the board, thoughts on how that's phrased?
I'm okay with that, Mr. Chair.
Yeah, I'm fine with that. I guess leave it up to whoever collects this in the future to enforce it.
I'm good with it, Mr. Chair.
Okay, Chip, is there a motion?
Yes, Mr. Chair, for Board of Building Appeals, case number GLD 20-0001. The, and I don't have the,
Citation number?
well, the citation number is 2020-0001 for the premise.
Chip, Susan did send out a motion form.
Oh, that's right.
Just right before the hearing.
Yes, you're right.
It'll make it a little bit easier.
So, yes, thank you. For Board of Building Appeals case number GLD 20-0001, the respondent is Les Irvine of Irvine Wood Recovery Incorporated at 110 Glendale Milford Road, Loveland, Ohio 45140. For the premises Irvine Wood Recovery Incorporated at 110 Glendale Milford Road, Loveland, Ohio. The appellee is Steve Kelly, Chief of the Miami Township Fire Department, and citation number 2020-001. Due to the overwhelming evidence and testimony, I move to uphold the citation and assess a one-time civil penalty of $1,000 for each of items 1, 2, 3, and 4 for a total citation of $4,000 to be held in abeyance so long as there are no future citations of the same nature at that same premises.
All right, that motion's been duly made. Is there a second?
Second, Mr. Chair.
Okay, that's Mr. Gehring. And before I call the roll on that, Deputy Chief Jetter and/or Chief Kelly, Les Irvine is the responsible person, and he was served. Is that correct with the citation?
Yes, sir.
Very good. All those in favor signify by saying aye.
Aye.
Any opposed? The citation's upheld with that conditional sanction on a unanimous basis. Chief or Deputy Chief, anything further to come before the board?
Yes, sir.
Okay, thank you very much. That case is now adjourned.
Thank you.
Okay. Moving on to our docket, and we can probably move through this with some speed here. Case number 20-0025, the Legacy on Possum Run, Belleville, Ohio, has been continued until sometime in September. That was a Richland County matter. We had then 4 Division of Industrial Compliance cases, case number 20-0080, that has been continued until September 15th. Case number 20-0086, that has been continued to an indefinite date or a non-certain date yet. Case number 20-0077 has been continued until September 15th. And case number 20-0050 has also been continued until September 15th. And we had a fifth Division of Industrial Compliance case 20-0083 has been continued also until September 15th. We just heard the Goldman case, and then our case that was last to appear on last on our docket for today has been continued to September 15th also, and that is a Fayette County matter, and that is case number 20-0042. So that would conclude our docket for today. Susan, is there any new business to come before the board?
The only thing I wanted to mention is I sent you the 5-year rule review to look over, and if you could respond by Friday, that would be great. And then I'll give it to the Division of Industrial Compliance Legal Section to send out to the stakeholders. The other thing is I sent you a link for the diversity and inclusion training. It is mandatory even for board members. The deadline date, I believe, is August 17th to complete. Some of you already have. And lastly, I did a follow-up email to Josh Nagy, our Assistant Attorney General, regarding the Upper Arlington appeal. I still have not heard back from him. I'm not sure.
Well, it looks like the city and the school district have filed a joint motion for summary judgment in front of the Common Pleas Court. So they obviously have sided together on that. It'll be interesting to see how the court rules.
Okay.
Okay, and I thought I did the diversity training, but didn't we do this just back in like May or June? Or is this a new one?
This is something different. Yeah.
This is a new one.
Okay.
Yeah.
It's
All right.
not very lengthy. It's like, I think each course, there's 5 of them, and they're like 3 to 4 minutes each. Then you take a test at the end. Doesn't take a lot of time.
Right, okay, that's fine. All right.
That's after the first one, and I didn't know. I thought you had to take it after each one. When I did the second one, the questions were the same. So I was good to go.
Okay. All right, well, do we have then a motion to approve minutes from our last 2-day session, which was July 30th and July 31st?
Still moved.
Do we have a second?
Second.
Okay. All those in favor signify by saying aye.
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 Any opposed? The minutes are approved for July 30th and also for July 31st. Do we have a motion to to compensate us for our preparation and our participation in today's hearings.
So moved.
Is there a
Second.
second? Okay, all those in favor say aye.
Aye.
Any opposed? All right, so we stand to be compensated for our preparation and our appearance today, which is August 11th. Our next hearing will be Monday, August 17th. That appears to be still virtual. That begins at 12:30 p.m. And if there's nothing else to come before the board, I'd call for a motion to adjourn.
So moved.
Is there a second?
Second.
All those in favor say aye.
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 Any opposed? Okay, we stand adjourned again. Next meeting is August 17th at 12:30, virtually. I know that Susan has sent out that agenda and those cases as they exist for the moment. And everybody enjoy the balance of their week, and we will obviously chat soon. Susie, thank you. Susan, thank you.
Thank you. Take
Okay.
care.
Thanks.
Bye.
Bye.